On Friday, the conservative Supreme Court issued a landmark ruling that undid over 40 years of precedent. Now, they overturned a 1984 decision known as the Chevron deference. That decision basically said that federal agencies should be allowed to fill in the details instead of courts when the laws passed by Congress aren't necessarily completely clear. So, I mean, let's be honest, that happens a lot because turns out our legislators are not exactly experts when it comes to the nitty-gritty details of things like science, regulation, etc. And so, yeah, they will pass legislation that isn't entirely clear, and basically the Chevron deference allowed these agencies, for example, the EPA, to be like, okay, we have experts, we know what they're talking about. Here's how we can best do this regulation. So now, instead, what we're going to have now are courts that are going to be able to make that decision. This was, now, going back to the Chevron deference, it was decided back in 1984 in a 6-0 ruling. Now, 3 of the justices ended up recusing. That's why it's 6-0. And it said that judges should basically play a limited deferential role when evaluating the actions of agency experts in a case brought by environmental groups that challenged a Reagan administration effort to ease the regulation of power plants and factories. So, yeah, basically it makes sense. Listen to the experts when it comes to these details of regulation. Don't listen to justices, to judges. In fact, Justice John Paul Stevens wrote in 1984, "Judges are not experts in the field and are not part of either political branch of government." Makes sense, right? Yes, this should be left to experts, not judges. That decision has been the basis for upholding thousands of regulations by dozens of federal agencies, which is why conservatives hated it. Lower courts relied on this doctrine for over 18,000 times to determine environmental regulation that may have stopped multinational corporations from polluting. Once again, that's why they don't like it. The High Court has also deferred to the doctrine about 70 times up until 2016, agreeing that they should defer to a government agency's reasonable interpretation of an ambiguous statute. But as I said, now it's gone. Okay, it's gone.
Bing, 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 boom. It's gone.
So that's 40 years of precedent and tens of thousands of regulations that now are open to be challenged by conservative organizations like the Koch brothers. Now, for example, or the remaining Koch brother, Koch Industries. In a dissent in the case, Justice Elena Kagan wrote, in her minority opinion, given Chevron's persuasiveness, the decision to overrule the doctrine is likely to produce large-scale disruption. All that backs today's decision is the majority's belief that Chevron was wrong, and that it gave agencies too much power and the courts not enough. Now, understand that this is a power grab by the conservative Supreme Court. Okay, they want to make the decisions on these regulations because I mean they think, oh yeah, no, we're more of an expert than the actual experts. Now that's not actually the reality. What they're doing is that they're just working for these conservative organizations like the Heritage Foundation. Okay, Heritage Foundation, and then you have billionaires that basically have been showering people like Clarence Thomas, for example, and Justice Alito with massive gifts. Okay, these are industry titans that are now going to be able to challenge these regulations in courts and now have judges that are going to be able to make the decisions on this. This is disastrous. In fact, Kagan writes, but shifting views about the worth of regulatory actors and their work do not justify overhauling a cornerstone of administrative law. In that sense, too, today's majority has lost sight of its proper role. Right. Proper role is to defer in these cases where they don't know the particulars to experts and how they do regulation. They're not doing that. Now, one example here she gives is, quote, when does an alpha amino acid polymer qualify as a protein? I don't know many judges who would feel confident in resolving that issue. But the FDA likely has scores of scientists on staff who can think intelligently about it, maybe collaborate with each other on its finer points, and arrive at a sensible answer. Now, the issue here, and why conservatives targeted this, is that they might not like the sensible answers because it could cost their donors extra money. That's why they would rather have judges appointed by bought presidents, confirmed by bought members of Congress through illegal campaign contributions or bribes, who can now, thanks to the court, an earlier decision, that can get essentially tipped by corporations for legislation that they have passed to make those decisions. Yes. So you can give money throughout the entire process. You can't get the money to the judges directly, but you can give them gifts. Okay? You can give them gifts. You can also give the president gifts. You can also give them campaign contributions to help them get elected, to get put into these positions of power, to which then, of course, as we saw with Trump, once he got into power, he got a list of Heritage Foundation judges, of which he was able to appoint 3 of them and to have all 3 of them confirmed. So, and by members of Congress who are paid by the same corporations that fund organizations like the Heritage Foundation. And so you end up having that. It just shows that our entire now judiciary has been bought by these donors. And that's why they're making these decisions, which are, of course, going to help the donors. So this is what you have. Okay. Now, Kagan writes, by overturning the Chevron doctrine, the Supreme Court's majority demonstrated that it disdains restraint and grasps for power. More reaction to this, former Solicitor General Neil Katyal told MSNBC that this is going to change government as we know it. It is impossible to overstate how damaging, this is Los Angeles Times' Jackie Colm. It's impossible to overstate how damaging to governance and to protections for air, water, food, and drug safety, worker rights, and so much more the SCOTUS overturning of Justice Scalia's Chevron doctrine is. This is a landmark decision. If only Americans understood how bad it was, or how bad it is. Policy analyst Ashley Chung said that the move was just like the Koch brothers asked. This is a key plank of the MAGA attack on the government in the administrative state and will reverberate through the entire federal government, explained democracy lawyer Mark Elias. And so the response to this from anybody who actually cares about food, water, safety, regulations are speaking out, all while conservatives, corporations, people in Congress that are owned by these corporations are cheering this decision on. They have won. Giant corporations, conservative lackeys have won. Expect now to see many, many challenges in the courts on things like the abortion pill, on the EPA's regulation, ability to regulate greenhouse gases, and so much more. This is a terrible day if you care about clean air, clean water, safe food, and safe drugs. Now the corporations are going to have carte blanche to be able to launch lawsuits to further dismantle the administrative state. And this is just, another part of Agenda 2025, the dismantling of the administrative state and the ability to pollute and basically allow corporations to do anything they want to us, to our land, to our food, to our water, to our environment, and of course to destroy worker protections. I cannot stress how much of a disastrous decision this is. Thank you for watching. If you enjoyed this video, please like, share, subscribe, hit the bell icon in order to get notified whenever a new video is released. And if you want to support independent, progressive media through this difficult time where it seems like everybody is shutting down, you can become a member on our YouTube page, you can become a subscriber on Facebook, or you can go to my Patreon. It's patreon.com/GeorgeCampbell. Jeff Waldorf. Thank you.